I'm Dr. Barry, licensed psychologist, and here I share legal and entertainment news from a psychological perspective. And I was over in the chat over on Emily D. Baker's channel. She is covering the motions hearing, and then also the lawyer I know he has a live, I think scheduled for 3:30 p.m. Eastern today. And I love hearing the lawyers' perspectives, and I'm looking at Sarah's behavior. And while I do not know what's going on with her specifically, I can talk in general just about just general thoughts based on my knowledge and understanding of psychology. Only someone who has met with her will know exactly what's going on with her. And that's why I am looking forward to the expert testimony in this case. If you are new to this case, please know I have a playlist. Sarah Boone playlist with all of my past coverage of this case. Somebody commented mentioning that some issues around alcohol and some other things came up today. And I am going to try to find the clip where the prosecution reads through exactly what their depraved act, exactly their thoughts on the case, because that's something that the defense had been asking for. And so welcome to everyone. I think Donette was first in the chat, and just wanted to say hello to everyone as we check this out together. Let the sound for this hearing, the defense has their microphone facing away. And so if I need to turn my microphone down a little bit, and then the judge is speaking directly into his mic, so the judge is loud. The prosecution, to me, theirs is like medium, and then the defense's sound is very low. And I might have to pause the defense at times. If you would like to watch this without any of my commentary, please know I always include the links down in the description. Okay, let's hop right into. So I wanted to make a note of. So the papers are sitting in front of Sarah. I have rarely seen the documents and things that the lawyer needs sitting in front of the defendant, or if the lawyer needed it, the defendant not push it over so the lawyer could have it, but like he's having to lean over Sarah to go through all of this. And she's not at all phased that this is likely uncomfortable for him, like having to lean over somebody versus just. So these are his record, like these are things he needs, but I think she wants control. And my personal thought is that she is in control of this defense. And towards the end of this hearing, Owens is going to say that there are people that Sarah want to be called that he might not call. And it's just all right. So let's hop into this part of the hearing. I'm going to skip through portions of it. All right. They're not talking yet. And this does not have closed captions available. Oy.
Okay. All right, Mr. J, you may proceed.
Thank you, Judge. We are referring to a rough draft printout that the court reporter made. It's 4 pages of part of your rulings there were several motions yesterday, but in this one, it's on page 1, lines 22 through 24. Part of the court's ruling was it's indisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court prior to battered spouse syndrome evidence coming in. And perhaps the state wasn't clear in its request, and I apologize if I was not in our motion, though. But paragraph 24 of the state's motion includes a quote from the Holland case. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. Holland versus State, 916 Southern 2nd, 750, page 760 of that opinion, a Florida Supreme Court case from 2005, which was quoting Quintana, Quin.
We are watching on 1.25 speed. Okay.
TANA versus State, 452 Southern 2nd, 98, page 100, a Florida first DCA case from 1984, also quoting Williams versus State, 252 Southern 2nd, 243, 246 is the page, Florida fourth DCA, 1971, Reed, REID versus State, 213 Southern 3rd, 1110 at page 1111. Florida 50 CA 2017. Rudin versus State 182 Southern 3rd 724 at page 726. Florida 1st DCA 2015. So what we were asking for is in addition to the battered spouse syndrome expert testimony to not be mentioned prior to an overt act being laid was any evidence of the victim's character, including reputation or prior bad acts. We apologize if that was not clear, since the motion is titled the battered spouse syndrome evidence, but the backbone and basis of that battered spouse syndrome is obviously prior bad acts by the victim. So we are seeking a pretrial ruling as well on the admission of prior bad acts, specific bad acts, or reputation evidence of the decedent.
Thank you. Response.
I just have one question as to what time. Are we talking about before dire? Are we talking about opening statement? At what time are we talking about?
During the testimony in the trial.
That was my takeaway.
Okay, he's absolutely correct.
Okay, the motion's granted. So the court's going to rely on that specific excerpt in Holland 917.
And so my understanding of this is so the state did not want any mention of prior bad acts to come in until Sarah has laid a foundation for self-defense, battered spouse syndrome. And that's the prosecution got a win there.
6 7 seconds 750 at pinpoint 760 through 761. Beginning with, as a general rule, evidence of a victim's character is inadmissible to prove actions in conformity with it on particular occasions, section 90.4041 Florida statutes. However, when a claim of self-defense is raised, a defendant may introduce evidence of a victim's character to establish who the aggressor was, or that the defendant was apprehensive of the victim at the time of the homicide. Internal citations omitted. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an, quote, overt act by the brackets victim end bracket at or about the time of the bracket incident end bracket that reasonably indicated a need for bracket self-defense end bracket, internal citations omitted. That's the standard. So hearing no objection from the defense, the motion will be granted.
Judge, just understand, clear on the record. It's just procedurally correct. Procedurally, before we can put evidence of that, there has to be a claim of self-defense. That has to come from someone.
This is so hard that this isn't like spoken into a microphone.
In this case, we don't know that has to come from.
Okay, received and understood. Any other clarifications for the purposes of opening or trial based on the court's oral rulings on the state's motions in limine yesterday?
No, Your Honor. And then the only other thing that the beg of the clerk of the court and the court is just that we can have some written rulings, even if it's just minutes from all the motions that were ruled upon yesterday at some point for the record for the 6th DCA.
Okay.
Yes, ma'am.
All right, thank you. Anything further from the state before we proceed with the objections? Defense.
Judge, yes, just my overall understanding is that the motions and the orders that the court has apply to trial and the organization or the flow of the evidence at trial. Certain things have to be presented before certain witnesses can testify. It has nothing to do
I saw this on court TV that Sarah was denied snacks.
That is correct, and the court ruled specifically on that yesterday. And that's in the excerpt that was provided to you and your co-counsel. All right, thank you.
I also believe part of the court's ruling was that the testimony that was proffered, the expected testimony of the defendant that was given to the experts, I believe the court's position was if that is the testimony, then that is not an overt act.
The court's statements yesterday speak for themselves. I'm not going to rehash that matter today. Anything else, Mr. J? Anything else, defense? All right, let's proceed with these objections. The court again has had the opportunity to review that 5th amended reciprocal discovery exhibit list filed by the defense, I believe back on October the 2nd or the 3rd.
I might have to pause it. I might have to fast forward through a part of this because I think there are issues with parts of this, but I'll just play this part.
And the court was provided yesterday the actual exhibit list itself and the state's response and objections to same. There's no need to go over the items for which the state has no objections. So state, I would ask you just to provide as the ones that you have objections for, and I have notes with regard to all of them. So you may proceed, sir.
One by one, I assume.
I think that's the easiest way to go. I know we start with item 1 and then go to 3, 4, et cetera. So we can ping pong it back and forth from there.
All right, regarding item number 1 on the 5th amended reciprocal discovery exhibit list from the defendant, I do not believe we've received those records.
Response from the defense.
You're referring to 1A1?
We're referring to 1. 1A is all the state's evidence that you believe you can use, and I labeled that as paragraph 0 in my response. So specifically talking about your paragraph that you labeled 1, certified medical records from Advent Health Orlando, paren, not yet received by the defense, paren. It's not yet received by the state, paren.
The defense has not received those records.
Motions or the objection is sustained. Moving to 3. Are these the 550 pages that we addressed yesterday?
My belief, and again, none of the exhibits are numbered as
You can tell that the prosecutor is frustrated, understandably, because I think the defense at the last minute is submitting things, and he is having to work. And normally you would have to work at night and things, but there are things happening now in this case that typically wouldn't happen. And I don't know if the prosecution feels that the defense is trying to bury them with unnecessary paperwork and is trying to like hinder I don't know. I don't know what they are, but the state is definitely frustrated that they keep getting things late. Definitely, definitely.
as they get disclosed to the state. They're not Bates numbered. I do that myself. But what I have and what I believe is states 2 was 81 pages of records regarding treatment by.
I'm not talking about 2. You don't object to 2. Talk about 3.
Well, I do need to talk about 2 now because
Okay.
This morning, after having previously already been given 81 pages of records that purport to be from Winter Park Advent Health regarding treatment of Sarah Boone over a variety of different dates spanning 2018 to 2020. After having received those, reviewed those, and made my decision on not objecting, this morning I was given a thumb drive from the defense, which contained 119 JPEGs rather than a single PDF with 119 pages. A JPEG, for the record, is a digital picture. They were upside down, they were sideways. I got them all formatted. I was able to read them while we were waiting for Madam Court Reporter. They do not appear to be completely the same as what has been previously provided by the defendant in regards to Winter Park's Advent Health treatment of Ms. Boone. So I just want to be clear that now, since the state's response, there has been some sort of change in what those records purport to be. And we are objecting. We are requesting a Richardson hearing regarding the 119 JPEGs that we were provided this morning.
Ugh. And I hope a lawyer explains because I haven't heard Richardson hearing. What is that? Ooh. Is a hearing to determine whether there has been a violation of discovery rules. So that is what they are about to do right now.
In regards to defendant's exhibit number 2.
At this point in time, the court is going to proceed with a Richardson hearing. Defense?
Judge, referring to our paragraph 2, the defense
Correct. My understanding, based on what Mr. J just provided, and based on his response, is that there were 81 pages provided to the state on or about September 27th, 2024. State had no objection to those. State further identified that this morning a thumb drive of 119 JPEGs evidencing something else was provided. And under the mandates of the 6th District Court of Appeal, based on Young v. State 369 Southern 3rd 1243, I am required to conduct a Richardson hearing. The court is conducting a Richardson hearing at this time.
Judge, the 81 pages.
The 81 pages are not at issue.
I'm saying that they will give Sarah Boone from the Advent Health report. The 119 pages, my understanding is we thought we had sent them previously. We realized yesterday or last night that we.
Okay, so I'm going to, because his volume is low, so I'm going to try to keep my volume low. So he is objecting, like he's trying to say he thought maybe everything had already been submitted. That's part of his argument, but it hadn't been submitted.
We had not sent them, so we provided those to the state as soon as we were aware that we had not given them.
And what do the 119 pages evidence?
They're medical records from the hospital relating to Sarah Boone over a period of time. So obviously that's going to be whittled down depending on her testimony and whether or not it would cooperate. Her testimony that she suffered an injury at the hands of George Torres.
Her medical records. Okay.
I need more specifics than that. I don't have.
So once again, remember, I have this sped up to 1.25 speed. Okay. So this was going slower than what I have it sped up to. I think Owens is upset that Sarah did not take the plea deal. If you all follow Tanika's 2 cents, I saw right before I got on, I watched a video of hers where she went over some of the disciplinary actions of Sarah. And one of the ones she covered, I think, was from October 6th. There was an argument between Mr. Owens and Sarah Boone that was overheard by staff to the point where the staff wanted her to like document and submit something to, because the staff overheard it. And she said she was fine. He said that, yeah, and everything was fine. But I think on October 5th, she was offered the plea deal again. And she denied it. And I don't know that Owens wants this to go to court. I think he knows he's on a sinking ship, and this is costing time and money that he's never going to see again. Never, ever going to see again. And the mic is, and so that's why the volume is so low. You can't hear what he's saying. Okay, I'm going to stop and play again if you have to adjust, because I started talking louder because I was getting excited. I don't think Owens wants this to go to trial. I think, I don't know. So, but he's doing his job as her attorney. He's doing what he can. He is.
Have a time frame. I don't have when. I don't have what.
Well, it's going to have to be matched up with the dates that she was injured, which would coincide with the.
But that all goes to the irrelevancy issue. We're conducting a Richardson hearing at this time.
That's what we're doing. Why is it late?
So I need to address the inadvertence or willfulness of the discovery. I need to address whether it was trivial or substantial. And if I don't know what's in these 119 pages, it's difficult for the court to determine whether or not this is a trivial or substantial matter. Are these items that were previously produced in the 81 pages? Are they different? Are they different events? Are they different injuries? Are they different things?
I think they're going to have to go back through it. I don't think he knows the answer.
Moreover, I need to make a determination as to whether this violation had an impact on the ability for the state to properly prepare for trial. Those are the 3 prongs that I need to address.
So she comes off reasonable, but she is difficult. And that's where I get more covert vibes. Like she seems like, oh, she's just sitting there, versus Ali Abulaban would be like freaking out and visibly upset and doing all of these things. She's just over there.
The first 81 pages were medical records of Sarah Boone that we had gotten from one of the previous lawyers that we had sent to the state. The other medical records were those that we had requested directly from the hospital that we got last week or late last week, and we just failed to immediately provide those.
When did you receive them last week?
I'm not sure, Judge. I have to get my secretary. We have to take a break, and let me find out from my secretary when we receive them.
Okay, I'm going to continue with the balance of the objections, and we'll circle back on the issue with regard to this objection so that you can provide when, where, how, what.
My staff is
Understood.
texting her.
All right. Well, I'll make a note to circle back to this issue. Moving to number 3. Is this the Advent Health Winter Park Jorge not yet received by the defense? State's response reveals a motion in limine was filed regarding this motion. Is that the 550 pages that we addressed yesterday?
Yes, Your Honor, the state still has not received a whittled down exhibit that they plan to introduce at trial.
Still.
The court ruled on that yesterday regarding the blood alcohol content records, and the narrative would be admissible.
I'm still waiting for those particular pages to be disclosed to the state.
Okay.
You want the exact pages? That those,
Yes.
Yes,
the VAC and the narrative are on?
that's what's going to be offered into evidence at this point in time.
We'll work on that right now.
Appreciate it.
I've got staff. You're in the courtroom.
So as with regard to the state's objection to item 3 that was previously ruled upon yesterday, is that the same with regard to the state's?
I'm going to interrupt. So Jenny Lou, let's talk. So Sarah Boone, the attorney that had her the longest was Padilla, and Padilla was, I think, less than a month out of court, and something happened in their relationship, and he withdrew, and then Sarah was given public defenders. Some of her 8 previous lawyers, I think about 4 of them, had to withdraw because of conflicts. So like when we talk about this being lawyer number 9, it's really more like lawyer number 4 or 5, but still that's a lot. That's a lot of lawyers. And the lawyer I liked the most was Miss Cashman. I think Miss Cashman would have put Sarah in her place. Miss Cashman was trying to do her job. I think she would have put forth a strong defense. Miss Cashman presented very knowledgeable. And to me, I think Miss Cashman would have done a great job for Sarah, but Sarah walked out of 2 meetings with her. Sarah Sarah continuously called her collect. And then so Miss Cashman had to pay for those phone calls out of her own pocket, which she did. So Miss Cashman did everything. Miss Cashman was known for being great with difficult clients. And so the court specifically assigned Miss Cashman and told Sarah, if this one doesn't work out, you're going to have to represent yourself. Sarah represented herself, I think, for like 2-3 months. It was bad. So Sarah trying to represent herself, it was bad. It was going to be bad. She doesn't understand, like she doesn't understand anything. Like it was going to be bad if Sarah had to represent herself. It just was. And so this is how we got to this point. Sarah wrote an ad. And when I say she wrote an ad, I mean there was a literal ad like that she drew. See, it was a beautiful ad. I don't know if you've seen it. Sarah drew a beautiful ad saying, "Oh, let's pull it up. Let's just look at Sarah Boone's ad for a lawyer." Oh my gosh, cuz it was pretty. We are going to take a look at it. Because Sarah Boone says, "Epic opportunity awaits." It's going to share this tab. An inmate seeks attorney. Looking for a prosperous challenge? Ready for your close up on national television? Are you zealous with a side of keen? Show the world who you are with your original creativity, extraordinary expertise, and confident ingenuity. Qualifications must include being trustworthy, honest, passion driven, open minded, exceptional problem solving skills, client inclusion at all times, team orientation, collaboration, extreme efficiency in listening, communication, understanding, dedication to success, possessing a winning mindset, capability of excellence in representation, committed to, I don't know, and committed, maintaining faith in the client and case with the ability to think differently, overcome all circumstances, including the video where I recorded my crime. So I'm not laughing because it's funny. I'm laughing like this is where we are. Okay. Epic opportunity awaits. Sarah Boone, her inmate number, invest in the oppressed, believe. I'm gonna come back to the chat for, oh no, it didn't show it. It's showing y'all. Okay, there. Okay, it was showing it. And then it went to an ad. Good. And then I'm gonna have to stop sharing because my browser lost connection with the sound. Let's put the other one back up. Okay, so that was real. So Owens answered that ad. I do believe that Jimmy, I'm bad with names. Her attorney, no, it wasn't an attorney. Her private investigator, his last name is Lane. I do believe her private investigator reached out to lawyers trying to get people to take her case. If you follow Uncivil Law has said on stream that Billy, thank you, I'm bad with names, Jimmy, Billy, that Billy Lane reached out to him about taking Sarah's case, and he declined. No thanks. So he took this case knowing her history. And so he is not a public defender. Owens and Henderson, and I'm bad with names, so there's a third one. She has 3 lawyers, and Bankowitz said, like, this was a case that needed more than 1 lawyer. And so Bankowitz felt that she likely needed, and for her case, for what she wanted, she was likely going to need more than just 1 lawyer. That's what Bankowitz always kind of thought. And so this is how we got here, okay? This is how we got to this situation. I hope that was helpful. Let's keep going.
Objection as to item number 5, certified medical records, Advent Health Ultimate Springs. George.
I believe so, without being able to tell. Advent Health, it just seems to all come from Altamont Springs, the records. So I believe that is all encompassing, but so we don't have an objection other than the ones previously noted for 3 and 5.
Okay, thank you. Moving now to item number 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they also have not yet been received by the state.
I think, did we address number 4? We went from 3 to 5?
Oh, I apologize. You're correct. 4, certified medical records, Advent Health, Altamont Springs, Sarah, not yet received by the defense. I'm assuming also then state you have not received them.
I believe the only records until this morning that I had was the 81 pages from Winter Park disclosed on September 27th, 2024. If there is something that they have from Advent Health, Altamont Springs, I don't believe I have that.
Defense.
Judge, we have not yet received those records. We had Sarah Boone sign a medical release. And
So the defense has things on their list. So this is their 5th amended evidence list. And there are things on this list that, number 1, they haven't provided to the prosecution. And number 2, they don't have in their possession either. So he's not going to object. The things that the state is bringing up, the defense does not even have, so they're going to remove it from the list. But it would have been easier for the defense to just remove these from the list, I would think. Not a lawyer, I'm a psychologist, but like that makes sense to me. I hate meetings. I hate wasting time. And so this seems like a bit of a waste of time to me personally, but we have to do this.
we have sent requests to various medical facilities asking for records. And we're just waiting on a response.
The objection sustained. Moving to 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they have not yet been received by the state either.
Last night, after business hours, I received 382 pages of jail records regarding Ms. Boone. Once again, I had to spend my personal time reviewing these records. Of the 382 pages, probably fewer than 5% refer to her mental health and the psychiatric treatment that gets provided to inmates at the Orange County Jail. The other 95+% of these records is all about physical treatment, COVID tests, things I won't outline here unnecessarily since I
Probably like feminine. I'm guessing there's like some medical. It's all the medical things you would get in 4 years.
do not believe these records will come in, but all of the things that you would expect a middle-aged inmate to have to go through for the course of 4 years. The state just is having great difficulty understanding what, if any, pages of these records are relevant. On page 135, there's records from part of her intake procedure on February 26th, 2020. On page 137, that's the initial screening when she came into the jail on February 25th, 2020. Page 137 and 138 include this initial intake screening. But from there, we get pretty far removed in time, pretty far removed in relevance. So the state is objecting to the introduction of these records. Even her intake screening on pages 135 through 138, I don't understand the relevancy of it. She indicates panic symptoms, She's semi-cooperative, has poor insight, unrealistic expectations, wants holistic treatment, doesn't like being housed alone. The screening on 225.
I think that record could possibly hurt her case. She is unrealistic. I'm going to rewind that one because this is the mental health part. So I'm going to rewind that part. That she might have some panic and some anxiety. So I did think so. Sarah Boone likely has anxiety. I think she, in my personal opinion, I think she used alcohol to self-medicate. And yes, so let's hear that again because I don't think this coming in, I don't know how this would be helpful to her.
To the introduction of these records. Even her intake screening on pages 135 through 138, I don't understand the relevancy of it. She indicates panic symptoms. She's semi-cooperative, has poor insight, unrealistic expectations, wants holistic treatment, doesn't like being housed alone. The screening on 225 goes through alcohol abuse, yes, type, spirits, not wine. Last used 22320.
So he glazed over that part. So I guess Sarah admitted to alcohol abuse. So in no other time, because during the interview, I think she told the detectives that she can't get drunk. And I think she denied having an alcohol problem. But then on this intake form, she's finally admitting, yes, I have a problem with alcohol. Okay. Like that's so if I was the state, but I'm not a lawyer, like it might be helpful for that to get in because to me, her behavior sounds like drunken inhibition and just like a ugh. Because the state, I've watched some of the state's questions to jurors. So you can only see Sarah Boone and you can only so you can't see any jurors, but they have I've seen some streams of the jury questions from the prosecution, and the prosecution asked if they are diagnosed with any personality disorders or if anyone in their family is diagnosed with personality disorders. They also asked about PTSD and they asked about DV. They asked, have you been the victim? Has anyone in your family been the victim? They also asked about, the normal, have you been the victim of a crime? Have you had bad experiences with law enforcement? And so all of those things. Uh, I'm surprised that and I get so the state doesn't want to be overwhelmed with all of this new evidence and not knowing how the defense is going to try to use it.
Several times a week. The intake screening also includes a history of violence towards others. Yes.
So in this intake screening, Sarah admits to a history of violence towards others. I don't know that I would be objecting to this to come in, but I'm not a lawyer. These are just my thoughts. I think this intake makes Sarah look bad to me.
So there's no psychiatric treatment records for treatment for trauma. Any of the recognized trauma diagnoses in the DSM-5, PTSD, or any of the other trauma symptoms
before.
that can be diagnosed. There's no records of any treatment of that. It's just the anxiety, which, having read the expert depositions, I'm sure you understand that was pre-existing before the jail. So our objection is we don't understand the relevance of these records. They do not go to her subjective state of mind on February 23rd, 2020. They do not go to help us understand whether somebody in her position was objectively reasonable on February 23rd, 2020. And quite frankly, most of it's just embarrassing and irrelevant. And it would bog the jury down, much like 487 pages of Jorge Torres's records. There's just
embarrassing and irrelevant. Dang. Okay. I wonder if the state really wants this in. I don't know. I could be wrong. The approach with this, because Sarah's not going to like any of these words, and she is driving this ship. She is the captain. Don't get it twisted. She is controlling that other side. It's all dependent on what Sarah says. It all depends on what comes out her mouth. We don't know, Judge. Like it all depends on Sarah. What we're gonna say. What we're gonna bring in. Sarah's controlling this whole thing, in my personal opinion.
a lot of COVID screenings and blood test results, and we struggle to see the relevance, Judge.
Thank you. Response?
Judge, it's similar to the state about 10 days ago, sending me over 500 pages.
We addressed that yesterday. That's not germane to the.
I'm laughing because so the state is trying to be upset about getting evidence late. And so the defense is going to be like, hey, we've gotten records late too. So,
The issue.
As soon as I got the medical records, I sent them to the state. He mentions anxiety was pretty.
So he said, as soon as I've got the medical records, I sent them to the state. I'm going to repeat some of this stuff because it is hard to hear. I'm not going to repeat every word, but I'm going to try to repeat the important stuff.
Existing. No, that's not what their expert, Dr. Werner, opined in her deposition, that the anxiety she may be suffering from at the jail was from being in the jail. So there are questions about that, but generally you get these records, as you know, when you have a forensic psychologist that's trying to evaluate a patient.
What is the relevance of these records? What do COVID tests have to do with anything in this case? What do blood tests have to do with anything in this case? If they don't, then what of these 382 records, 382 pages of records are relevant?
I'm trying to tell you.
Okay.
What specifically is relevant? What page?
Dr.
What
Harper,
date?
Dr. Harper,
What document? You're not answering my question, counselor.
I didn't say we were going to introduce these records.
They are listed on your exhibit list. The state is taking the position that these may be sought to be entered into evidence.
I don't intend on introducing these exhibits, this exhibit evidence. I intend on potentially the doctors, the experts, Dr. Werner, Dr. Harper, to rely on these records.
So I think Sarah might have wanted this in. Like you can tell when he says something Sarah doesn't like I think she might even kind of be giving him a certain look right now. Like I think Sarah wants this in. I could be wrong.
The depositions of all three doctors predate their request for these records. So it's pretty unclear whether any of these experts have already reviewed these records. Now we're going to have to address, when do I get to depose their doctor, Dr. Harper? If she has not reviewed these records yet, when do I get to depose her? Who's going to pay for the expedited cost for the transcripts? What relevance is it to her if she hasn't reviewed these records? They got these records post deposition, post evaluation. The last date that I believe she saw Ms. Boone was September 30th or October 1st. And then we took her deposition either the 1st or the 2nd. So this is also a problem, even if it's just going to be relied upon and not introduced. And I appreciate them letting us know that they don't seek to introduce these records into evidence, because of course, experts can rely on inadmissible evidence if within the course of that area of expertise, it's the type of evidence that's routinely relied upon. But how are these records relied upon if they acquired them after we've done all the depositions? Now, Dr. Harper did say that she relied upon some jail records during her deposition. State didn't have those at the time. I don't know what the date span is of the records that she did review at the time of her deposition. So now we have new issues to confront. We would like to know whether or not their experts have been provided these new records so that we can address that.
Mr. Owens?
Judge, I don't want to delay the trial. I'll wait. I will not have Dr. Harper review.
So she has not yet reviewed these yet, correct? Okay.
I don't want to get in a situation where we're going to take another deposition. So I'll wait. I will not ask her to review.
If they did have to do another deposition, the defense would have had to pay for that. That would have come out of his pocket if they had to do another deposition. That's my understanding of what's been said.
Okay. State with,
That was the only purpose.
okay. So state, understanding that tactical decision and that Dr. Harper is not reviewed and seemingly will not be relying upon these experts, does that cure any concerns that you have?
Yes, sir.
All right. Then based on counsel's representation, the court's not going to sustain or overrule the objection, as the defense has identified they're not going to be seeking any of these 382 pages into evidence. Moving now to 8, 9, 10, and 11. There's no issue with regard.
I'm going to get back because they're talking about pages 8, 9, 10, 11. So I think if Sarah Boone is found guilty, I think she's going to blame Owens. She's going to blame the court. She's going to blame the judge. I think she lacks the ability to accept responsibility. Those are just my own personal thoughts.
To the body cam footage, but there is to the police report itself. What is your response to that, Mr. Owens?
Judge, the arrest reports are not listed as evidence in itself, but the reports may be used to refresh the officer's memory if needed during their testimony.
Does that cure that understanding?
Yes, sir.
Okay, all right. So based on Mr. Owens' representation, as those items will not be sought to be moved into evidence.
So whatever those numbers were, they're not going to enter it into evidence. Jessica, this is a great question. Is it a thing for a narcissist to snap under pressure? I see a possibility of her showing her true colors in trial. But so her leaks are nonverbal. So her eyes start blinking a lot. She's very controlled. I don't think if she's found guilty, like I don't think she'll have a big but I don't think she'll have a big tantrum. So Aliyah Boulabon. So please know when we talk about narcissism, it's a spectrum and there are different presentations and people can have traits and features and not meet criteria for narcissistic personality disorder and everybody on some level has some features of like so like in a certain situation like an interview I might for a job that I'm not completely qualified for I might present really well like I am qualified for it and I might do things in a certain way that I don't know might come off I don't know but like I don't like I might try to act and present as though I know more than I know I don't know like job interviews I think can be an example of acting and kind of putting your best foot forward but the root of narcissism is a lack of self and a lack of ego their ego is incredibly fragile and they can't take feedback they externalize blame. And when I say externalize blame, everything is everyone else's fault. So Sarah does not take responsibility. They are going to bring up alimony and Brian Boone later. And we are definitely going to talk about that part later. For anybody that has experienced this type of harm, Dr. Romani is a phenomenal resource. I see her as covert and so sometimes vulnerable. So the way I like to describe some of these features and so I don't know her diagnosis and I don't know if she would meet criteria for for the full disorder, but I personally see possible symptoms of covert where when you first meet them you're not sure, but then so Dr. Romani is absolutely amazing. I do think that she likely had traumatic experiences in childhood or things that she experienced as traumatic and stressful or ways that she perceived that family was not there for her or this or that. And because of some of those experiences, her personality may have formed in a certain way. And then I do think that she used alcohol to cope, which made things 20 times worse. So those are just my own personal thoughts. Let's keep going.
And so received into evidence, but only for the purposes of refreshing a recollection. The objection is not sustained nor overruled as they're not going to be sought to be entered into evidence. Moving to Exhibit 17. No, I'm sorry, 16. 16 is a repeated of 11, so the court's going to adopt its, similarly with regard to that exhibit. Mr. Owens, are you only going to be seeking the arrest report for the purposes of refreshing?
Yes, sir.
Okay, so court same ruling with regard to Exhibit 16 as with 9, 10, and 11. Moving to 17, the jail calls involving defendant and third parties. State, anything else to add other than your written objection?
No, Your Honor.
Response?
The defendant is not intending to introduce the jail call.
Okay, the objection is sustained. 18, prior criminal history of George Torres not yet received by the defense. Has the state received that?
Other than the arrest history that has resulted in interaction with the state attorney's office, we have not. He's not a testifying witness. So obviously we have to provide, if they can't get it through due diligence, rap sheets of witnesses, but he's not a witness. So we have not done anything other than had discussions about prior interactions with the state attorney's office.
Okay. Response, Mr. Owens.
So we're referring to the prior record involving Sarah, that Sarah's aware of.
I wonder why they didn't request that.
I know we had some priors in Pennsylvania and Massachusetts. We're not referring to those. We're all referring to the ones involving incidents involving Sarah.
Nope. So this is from this
I'm
morning.
just trying to understand, are they seeking to introduce some sort of paper, or is this just the broad notification that Ms. Boone, when she testifies, will be testifying about any prior incident of violence that she wants to regarding the decedent, because you can't rebut it?
What is it? Is this oral testimony? Because this is an exhibit list, so that's my confusion. If it's oral testimony, that may be a different critter.
So I think they put something on the exhibit list that they don't actually have. So I think the defense wants his criminal history, but I don't think they have it. And that's where the confusion is coming in. Because we're going over the defense exhibit list.
Once the overt act is established under Holland.
Judge, she's gonna testify to it, and then,
Oh.
it kind of ties
She can't
into
testify.
That evidence being used to refresh the officer's testimony. The officer's testimony, we believe, is going to cooperate. Sarah Boone's testimony without her injuries, photographs, officer physically observing injuries on her. That's the nature of this. So I don't think there is going to be anything about a prior criminal history other than what she's testifying to.
Okay, so there's not going to be any documentary or physical evidence that's provided, informations, charging affidavits, a criminal history report, anything tangible that's going to be offered to establish that criminal history other than Ms. Boone's testimony? Is that your position?
Yes, unless there's some dispute about that we have to cooperate and ask the court to take some judicial notice that there was a case file that was set up to handle that criminal prosecution.
Okay. Mr. J?
I don't know that papers generated by a government agency is relevant. The disposition of the papers that were generated by some government agency is relevant. What's relevant is if there is an overt act that gets testified to, prior instances of violence by the decedent that she is aware of. That doesn't open the door to hearsay. That doesn't open the door to any of these things that he seems to be referring to, whether it's criminal rap sheets, which is what I believed he was referring to, or police reports, or state attorney records of no bills, or I don't know. Based on his last statement, I don't know what we're talking about now, but we do have hearsay objections to, I thought we were talking about physical exhibits. And that's what our objection would be to, believing that what was represented was a criminal rap sheet.
Judge, part of battered spouse syndrome, and Dr. Brennan will testify, I see Dr. Crump will testify about it, Dr. Warren will testify, is this feeling by a victim of being battered.
So Owens does turn Sarah into the victim and like, so, but that's her defense. Okay. So he's talking about how like part of their defense is going to be, the things that have happened in the past. And that's what she was afraid of. I believe that that's what he's going to say.
She has nowhere to turn. His family can't help her. She has no group. The state attorney dropped 3 of the charges, 3 separate times.
They dropped the charges when she asked them to, I believe, but okay. And that can be, so in instances of DV where, yes, so that is something that can happen. I do not believe that's what's happened in this particular case. That's just my own personal thought. I believe that Sarah attempted to use the justices, like the courts and all of that, to bend to her will and to punish him. She comes across very vengeful to me, like she wants to punish people. And because even with her ex Brian, she still expects him to pay her alimony while she's in jail. Like, and he's like, what? Like, no. And she still expects, I don't know, like it's just so odd. It's so odd.
Torres was arrested, charged with violence against Sarah Boone. And her request, she wanted to drop. That's part of the syndrome.
Same.
But in addition, in her mind, she felt like the state attorney had let her in. They could not, they dropped 3 of the cases. So she felt helpless that there was some outside entity that would protect her. That ties into her state of mind as to whether or not she felt an imminent threat at the time of this event. So that may become relevant depending on what Dr. Harper says, Dr. Warren says about that, what Dr. Brandon says about that, as to whether or not she felt helpless because the state attorney's office was not prosecuting George Torres when she was.
But that all sounds like oral testimony. And again, this goes back to, this is an exhibit list. What are the exhibits? Tangible, physical.
We may want to introduce something in a court record indicating that the state attorney dismissed it.
Okay. What does that have to do with prior criminal history? Because that's the topic here. Prior criminal history of George Torres Jr. not yet received by the defense. That's the line item in your exhibit list.
I will withdraw the prior criminal history.
Okay. All right. So based on counsel's representation of the withdrawal, the court will not sustain or grant the objection. Does that clarify that for you, Mr. J?
Thank you.
All right. Moving now to 19, Orange County Sheriff's Office investigative workup report. Response.
That's to be used to refresh the officer's memory if need be during their testimony.
Okay. With that understanding, Mr. J.
Yes, I'm not clear what a workup report is, but if it's not sought to be introduced into evidence, then I will accept that representation.
Okay. So accepted. Your objections overruled based on counsel's representation. The investigative report workup will not be offered into evidence, but merely for refreshing. Moving to 21, all court orders in all Orange County criminal cases regarding George Torres. State. Any further argument?
I believe we went from 19 to 21 without addressing 20.
Oh, I apologize. I had the wrong, I color coded this and I miscolor coded this one.
Wasn't introducing anything on 20.
Okay, then based on counsel's representation of withdrawing that, the court will not rule on that objection. Moving to 21, anything further? Because we kind of dropped.
So I am glad that the state is trying to protect George's reputation. So if she can't say anything that justifies self-defense, they are not going to be able to drag his name through the mud. And I actually like that because I think they're going to try to present him as this aggressive, evil person. And it sounds like how he lived his life. He was the one that played with her son. He was the one, like, he just sounds like he was kind. And now when he drank, maybe, like, I think things weren't good for them when they drank. But I don't think he was the main aggressor. Like, according to her ex-husband, Brian, she would get aggressive when she drank. And it's so, so sad. And so we definitely want justice for George. And for anyone that's new, he pronounced it George versus Jorge. And that's how his family refers to him. And sometimes that's common with where sometimes people, so I know a guy, his name was, I'm bad with names. It was Luis. It's hard for me to say it because he just let people call him Lewis until we were talking. And he was like, my name is actually Lewis. Like, that's how you're supposed to say it. But I just say, people just call me Lewis, whatever. And it was like, no, like, people should say your name the way it is. And I always get stuck. I'm like, I'm bad with names. I'm gonna do my best. Lewis. Like, that's how you actually say his name. I have a friend, her name is Khalida, but she goes by Khalida because that's the way most people say it. But the way that her mother named her with the Arabic meaning, that would be kind of a more proper pronunciation. And so it can be common that people have like an Americanized version of their name. And but for me, my name was always like a big thing. So I am Patrice. I'm not Patricia. I'm not Pat. Like, it is Patrice. It is not, it's not Pat. It's not Patricia. You can't call me what you want. Like, no, it's Patrice, Dr. Barry. Like, but it's not Pat. Nope. I don't do that. All right. And I see a question. Let me see if I can just go ahead and answer it. I see a question. When I told my hubby about this case, he asked were there drugs involved. So it's my understanding that there might be some benzo. There's a question mark of a diazepam injection or something like there. So I haven't seen all the evidence. I think there's questions of was there any benzo, like was something, but like maybe he was drugged, not that. So alcohol was the main thing. She sounds highly intoxicated. She sounds definitely under the influence in the video, but the only thing we're aware of, and they never did a drug panel on her. So to my understanding, she's never had a drug panel. They never took her blood alcohol level the next day at the scene. They never did that. All right. All right, let's keep going.
Address this as well with number 19. Anything further? Argument state. Anything further? Argument. Okay. I'm going to overrule the objection as this point in time, because if a declination of prosecution may have been filed, that may be relevant based
I
on
think it's yellow.
Ms. Boone's
I think it's yellow.
testimony. So I'm going to overrule your objection at this time, assuming the overt act concept is placed into evidence.
Okay.
Moving to 22, family law case file Boone v. Boone, case number 2017 DR 01660-O.
They are trying to bring in I missed exactly how they were trying to bring in the Brian Boone issue. So they want to bring in the family law case.
I understand the state's objection is to relevance and hearsay response.
Brian Boone, we anticipate is going to testify for the state, when he testified for the defense, and he may be considered an adverse witness or hostile.
Adverse
So
witness.
he may attempt to establish either bias on his part based on.
So they are going to try to say, the defense is going to try to say Brian Boone is biased because he owes her alimony. And it's not even clear because I believe the court paused his alimony. People have found some of the court stuff. I don't post. So I know because family court stuff is normally sealed. So I personally haven't posted any of that on my page, but I have seen it other places that Sarah Boone wrote these letters to the court, feeling like she's entitled. That she's entitled to the alimony. And he's like, you're in jail for second degree capital M. Like, no, I'm not going to keep paying you alimony while you sit in, because his alimony was $1,000 a month. And he's now the sole caregiver for their child. And she's only thinking of herself. Like, she's not thinking of how this impacts him, how this affects their child. She's like, no, I still want the money. No, like you still owe me $1,000 a month. And the court, I believe, paused it. And I've heard other places that it might be in like escrow or something. Like I don't know if it is, but there's something that it might be in escrow. But if she's found guilty, he's likely not going to have to pay her alimony ever again. And so I think the defense is going to try to say he's biased when Brian Boone from the start, the cops come up to him and he's like, hey, y'all have been here before. Hey, like they have a history. And so from the start, his story has never changed. And how dare they, because Brian wouldn't help her clean it up. So, okay. So for anyone that's new to this case, when Sarah Boone, the morning after, because the suitcase issue happened overnight, she went upstairs and went to sleep. The next morning, well, next afternoon, because I think it was after like 1 o'clock or something, she wakes up, she finds him in the suitcase. She calls Brian. She calls her ex. And I wonder if she wanted him to help her fix it. Because Brian's the one that had to say, Sarah, call 911. He was the one that had to tell her to call. Like, what? Like, I don't think Brian is biased at all. And the fact that they're trying to say this makes me mad.
Some of the documents or orders in court record or may reflect, for impeachment purposes, the fact that he has not complied with some of the orders, and that the reason being is because of his feelings for.
You can tell when Judge Cranick is like, what? And right now they're trying to talk about Brian Boone's feelings. Brian is trying to focus on raising their child. That's what Brian is focused on.
Defendant, he's now got full custody of their son, and has had full custody for 4.5 years. That was not the agreement he originally had, and he was ordered to pay alimony, which he has failed to do as a result of being incarcerated. So there's litigation going on.
He was ordered to pay alimony, which he has failed to do due to her being incarcerated. Why should he have to pay her alimony? And she like did a crime and is like, so alimony is to help you live. You don't have any expenses, ma'am. Like you are a ward of the state. Why does she need, not a ward, but like she's living on the citizens of Florida's dime. Why should he have to pay her $1,000 so she can get Pop-Tarts and cheese slices and mints and like what? I don't get it.
What does the non-payment of alimony have to do with what's happening in a family case?
Well,
Exactly.
Judge, that goes to his testimony, that goes to his credibility.
No, it doesn't.
He can be impeached that her in the position that she's in now, he's biased.
Due to her behavior.
Show that he's biased, that he has not paid alimony. He's supposed to pay $1,000 a month for a number of years, that he just failed to comply with the court's order. That shows his personal bias or feelings.
She probably gets Pop-Tarts from commissary.
Response?
Sounds like this is ongoing pending litigation that has not been decided by a circuit court judge in the Ninth Circuit Family Division. I can certainly understand why one may believe they don't need to pay alimony.
So often what happens in these situations, because the same thing happened with Shonda Vander Ark and even with Jody Hildebrandt and Ruby Frankie. So with Ruby Frankie, so rights aren't terminated. Family court doesn't make a decision until there's a legal decision with the court case. So right now, Sarah Boone probably still has like visitation or something. Like she hasn't lost her custody yet. If she is found guilty of manslaughter or second degree murder, Brian is probably going to file to have sole custody of their child. Please don't put his name in the chat. Y'all have done a phenomenal job not doing that. This is not about her child. Thankfully, he's kept out of this court case. I do believe the bat that was used in the commission of this crime, I think it was his bat. And this case has caused him issues at school. And because people like this case is popular, people know. And so I love y'all's humor. We're going to keep going.
When their spouse is incarcerated, I can certainly understand why somebody may believe they don't need to pay child support when their spouse is incarcerated.
Yes.
And they would probably want to seek legal redress about those issues. And it sounds like it's all ongoing.
Are there any orders from the court in that case addressing the non-payment of alimony and that being contemptuous or in violation of any court order?
No.
No.
They were divorced. I think there was a marital settlement agreement that was attached to the final order. Brian Boone did open the case back up to move the child to Gainesville, which has happened. And then my understanding is there's still some issues. I think she was given some kind of a notice of a hearing coming up. She's not represented. I don't represent her.
Is there, so if there's no order in the court file finding there's a violation of an order to pay alimony, what is?
Well, there's a final order about his obligation to pay alimony. And I think if he gets on the stand, I'm going to ask him, but you haven't paid her alimony like you were ordered to do so. I can go into under cross-examination.
But it sounds like there's pending litigation, including a relocation and I don't know because it's not my case. I haven't looked at it.
That's been decided. He has been able to relocate. I don't know all the ramifications. I'll look at the court file. I think we had subpoenaed the custodian of the records of the court file. I'll look at it and I'll let the court know and the state know.
Can you all approach this for a moment?
I'm glad the judge paused it because this should have nothing to do with Brian Boone's credibility, in my opinion. It just shouldn't. This shouldn't have anything to do with that. Let me know if I'm a little laggy because I'm at my office and let me just turn off the virtual background and see if that helps. Sometimes my screen, let me just see if this helps. Let me see. I still seem laggy. Let me know. Okay. I don't know. All right. Let me know in the chat if it's good. If you're watching on replay, welcome. Gonna fast forward. I don't think I don't think they should be able to bring his alimony because she did a crime or she was charged with a crime. Because she was charged with a crime, he doesn't have to pay her alimony. Like, I don't think that goes to his credibility personally. I don't think it does. And then so she's gonna like talk with, I think this is one of like the paralegals or something. And so it's just Sarah. I think I don't know.
And clarifications.
To the chat.
County Sheriff's Office regarding Miranda. Have those been received by you, Mr. Owens?
Yes, sir.
Okay.
I'm no longer seeking to introduce those.
Okay. All right. Based on counsel's representation, court takes no action on the state's objection.
Same with 24.
Based on that.
And Misha is a lawyer. So Misha Janice, I was able to catch her live with Tanika. And so with Tanika's 2 cents. And so this is another channel that covers Sarah Boone. Correct me in the chat if I'm wrong, but Misha is a lawyer. And so I love when people are able to share and finding new people to follow and all of that. I love supporting other creators, and I'm thankful for like the creators that support me too.
Representation, court takes no action. Moving to 25, records from Tealwood Park Apartments.
Judge, we never received what we wanted. We're not seeking to introduce that.
Okay. Based on counsel's representation of not seeking to utilize it, court takes no action on that objection. Moving to 27.
26, the defense does not intend to introduce any of the 911 calls.
Okay, all right, thank you. Moving to 27, the video footage of the arrest on February 25, 2020.
The defense has not received that. The state may have it in their possession. It appears there's news footage. Sarah Boone in handcuffs being escorted.
State, you have such an item in your possession? News footage?
No? Not that I know of.
All right, but we have not received it, so we don't have the evidence.
Okay, all right. Based on it not being received, court's going to sustain the objection. Moving to 29, the iPhone photo file name, not going to read it, it's very long.
Judge, I do not intend to introduce 29.
Okay, and court takes no action based on counsel's representation. Moving to 32, iPhone photo. Yeah, I'm sorry, sir.
29, what is the ruling?
There is none, as the defense has advised they are not seeking to enter it into evidence. 32, another iPhone photo file name, very long, so I'm not going to read it.
Defense does not intend to introduce.
As such, the court will not take any action on that objection. 33, another iPhone photo file name. Court's not going to read it because it is too long.
Defense does not intend to introduce.
Based on counsel's representation, court takes no action on the objection. Moving to 48, another iPhone photo file name, 505 period JPG underscore embedded underscore 1 underscore 772.
We would stipulate.
Okay, so I'm going to fast forward through this part because I think they don't end up getting a lot of the stuff in. So I'm going to fast forward because they're going to go through multiple pictures and most of it doesn't end up coming in. Okay, and then Owens is going to get up and talk. So let's start here. Hopefully the sound is better here.
Yes, sir.
Okay, good. The sound will be better.
Judge, Mr. J is a smart lawyer with a lot of experience. He's board certified. He's filed this motion in limine to disallow the battered spouse syndrome twice. And yesterday, we were forced to disclose the overt act that constituted our defense that tied in with the self-defense. And so tactically, he was able to get us to that posture. So he knows our defense and how we're coming at it. The problem is the state has not been forced to give the details of what they allege Sarah Boone's overt acts or non-acts.
I need to clarify something. There was no forcing yesterday. The court reviewed Dr. Harper's deposition, and there was no overt act that she had testified to. She was specifically inquired about any imminent fear, and there were.
So that is a problem. So when the doctor was asked, what overt act did Sarah Boone do, or what happened that caused her to be in fear for her life, the battered spouse expert was not able to answer that question. That's a problem. That is a big problem. And so I don't want to glaze over that. So the defense expert, the one they are bringing in, when she was asked, what was the thing that sent Sarah over, like the thing that happened in that moment on that day? Because Sarah says it was a good day. It was a good day. We were playing puzzles. We were doing all the things. And then I zipped him in his, like, he got in the suitcase. And then when he got mad, that's when I got scared. Like, that, what? Because he asked you to get out? That's what caused you to get mad? And remember all the time? Like, no, like, I don't think that's enough. I personally don't think that's enough. I'm not a lawyer. I'm not a lawyer. And so we will. So with Misha, and I'm going to send you, I'm going to put my email in the, I think if you go to my page, I think if on here on YouTube, my email is right there, but I'm going to put it down. But like, we should definitely plan something together if we can. And through my StreamYard, I'm able to, like, if we do it together, we can send it to our streams simultaneous, like all together. And then the chats all combine in StreamYard. And so that would be pretty cool. I've done that with Natalie Lawyer Chick. I'm planning, I might be on Surviving the Survivor. We'll see if that happens. I'm messaging with them to try to schedule a time to go on with them as well.
There was no response to those questions. The word overt act did not appear in any of the 4 or 5 sessions that she had with Ms. Boone.
None.
And state was seeking, as we addressed yesterday in limine, to prohibit that.
I disagree with that. That was his deposition. He tried to control the witness. He kept cutting her off. He wouldn't let her finish explaining. I certainly wasn't going to do it. She's going to testify in trial about it. It's not my fault that he felt like he got the answer he wanted and he moved on. He didn't ask for any elaboration about that, but that's going to come out. But I understand that's all you had. But we had to do that. The state has not had to do that. And I understand under the Sixth Amendment that we have a right, the accused has a right to be informed of the nature and cause of the accusation. And the problem with that boilerplate information is we don't know what they're claiming that she actually did, overt act or omission, that constituted second-degree murder. So because of that, we have to list everything because we don't know. It's like he wants to know. He wants the court to make rulings so that he can tweak his opening statement based on the court. The same with us. We don't know how to respond to their opening until they give it because we don't understand the full nature of what they're alleging Sarah Boone did to constitute second-degree murder. So in an abundance of caution, we've got to list everything that may be relevant, but we don't know yet because we haven't heard. I would like to renew, they've renewed their motion on battered spouse. I would like to renew my motion for a statement of particulars so that I could know, the defense team could know what it is exactly that the state attorney is alleging that Sarah.
So trigger warning coming, because when the state gets up there, the state is going to read out what George said. Okay, so the words and Sarah's response in that video is what made the state say second-degree murder. And I've said the same thing. That video, if I was on the jury, that video would be enough for me to say second degree. And if she had said that they were playing truth or dare, she might have been charged with first degree, because then it seems like were you planning on this if it was truth or dare? And so she says hide and seek. That's not how hide and seek works. I've covered that multiple times on my channel in almost every single video. That's just not how hide and seek works. Truth or dare would make more sense, but that seems intentional if it was truth or dare. So I wonder what they were really playing. Like sometimes people do drinking games of like truth or dare or take a drink. And so I don't know. The neighbors also say that they heard a loud commotion. And so I don't know that we'll get the truth from Sarah. And the only other person that knows what happened is not able to speak. And so I'm so glad that the state is advocating for George and his family.
Did or did not do that constitutes second-degree murder. It's a serious charge. This is not, it's a unique case. It's not something that happens every day. And that's why we believe that it was proper under that rule of a statement of particulars so that we could be informed about what it is exactly that they claim that she did criminal so that we could prepare a defense. And it goes directly to this point, which is they want to know why we want these documents and what documents specifically are y'all going to use. Well, it's difficult to tell when we don't know what we're accused of.
Any response, Mr. J?
Yes, sir. Mr. Owens, Mr. Cacciatore, myself, and Dr. Werner all sat together within 5 feet of Sarah Boone the first week of October
Trigger warnings.
and heard the final version. It's not very dissimilar from the version of Dr. Harper, but Dr. Werner's deposition was provided to the court previously for our motion to eliminate. I don't understand the position they're taking that they were forced to show their cards when Dave Cacciatore and myself and Mr. Owens and Dr. Werner were all there together to hear her version. And her version is, it was all fun and games. It was Sunday fun day. He gets into the suitcase. We're all laughing. I zip it shut. We're still laughing. There comes a point in time when he says, I can't breathe. This triggers her based on her past abuse, no overt act that day. And she begins violently doing the things to the suitcase that she says she did, whacking him with the baseball bat on his fingers. And now, after being the initial aggressor, now after having committed a forcible felony or two, now after having put Mr. Torres in a reasonable fear of death.
Before we get into the heavy part, the prosecution has some snark. I like the prosecution's And I don't know if he'll be that way in front of the jury, but I think he kind of has a dark sense of humor. And so Sunday fun day, like he's over here like, oh yeah, like we just, we're just having fun. And then all of a sudden, when he tries to stick his hand out, that's when she's all of a sudden in fear for her life. And instead of calling the police, leaving the apartment, all the other things she could have done, I can't. So this is about to get bad. Okay. For like, if it's triggering, it's going to be about a minute where the words are, I'm just going to let them play.
Death or great bodily harm, she says, well, she realizes now if he gets out after these things that I've done to him, I'm in big trouble. And it's my understanding that we have had this discussion, and that if that is the proffered testimony, that is not going to amount to an overt act, which will allow for reputation evidence, past incidents of violence.
This might not be when he says it, because it might have been it might be later, because the other guy comes up and they go back and forth. And so it might be later. We'll see if it happens now. It might be later. I saw clients in between watching some of this, and so I might be misremembering.
Violence or the battered spouse syndrome evidence. That they weren't forced to show their hand. I was there. The rules of criminal procedure allowed me and Mr. Cacciatore to be there and to witness this evaluation. So that being said, we're not abusing the system. We're not doing anything that we're not allowed to do. And we're making every effort to make sure that we understand how this trial is going to go down, and how and Ms. Boone understands how the trial is going to go down. Because my understanding of how it's going to go down is she's going to have to testify to the specific events of that day. And right up when she comes to the point to saying, and when he said, I can't breathe, the state attorney, Mr. J, is going to object. He's going to ask to approach. He's going to say, Judge, there's been no change in her testimony. Unless there is, then that's a whole different bag of worms. But if there's been no change in her testimony, Judge, we got a ruling prior to this that there's been no overt act testified to. Now we're going to object to her.
And this is where Sarah Boone does self-sabotage, and she gets in her own way. I think they likely had an argument. I don't think it was a good day. I don't think it was a fun day. I think she's minimizing. And I think she's lying. I personally feel, this is my personal thoughts, I think she's a pathological liar. I think she's lying about what happened. I don't think she said the true version of what happened. She's looked at the evidence and she's created a story that fits the evidence. But every time she gets more information, her story changes a little bit. The same way when she got on the stand after Detective Kopsel. So after the detective got on the stand and talked about the interrogation, all of a sudden now Sarah was drunk. I don't think her lawyer knew she was going to get up there and say that she was drunk, because the lawyer was like, I didn't elicit that from, like, she said that on her own. I didn't even elicit that from her, because it doesn't make sense. And yeah, it's really hard. It's really hard because this is, she treats it like George didn't matter, and he does. He really does.
Answer of because of the past violence, and we're going to object to any further attempt to bring in prior violence, reputation evidence, or battered spouse evidence. I just want everybody to be clear and on the same page about that. Now, in regards to their request, a renewed request for a statement of particulars, they've had the discovery for several years. This is the state's case. A video that starts at 11:12:45 p.m. on 2/23/2020. Sarah, for everything you've done to me. Sarah, for everything you've done to me. Sarah, F you, laughter. Sarah, F you, laughter. Sarah, stupid. Sarah, that's my name. Don't wear it out. Sarah, I can't effing breathe, baby. Seriously. Yeah, that's what you do when you choke me. Sarah, 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 laughter. Sarah, I can't breathe, babe. Laughter. That's on you. Sarah, I can't breathe. Laughter. That's on you. Sarah, unintelligible, drunken, slurred words. Laughter. Sarah, 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 I can't breathe, baby. That's what I feel like when you cheat on me. Sarah, F you. I can't effing breathe, Sarah. You should probably shut the F up. Sarah, shh. That's our case. That is an evinced, depraved mind, conscious disregard for whether he lives or dies, whether she put him in there or not. She let him remain for 2 minutes during that video. And then at 11:23:03 p.m., there's another 22-second video, and it just zooms in on the suitcase. Sarah. So that is a second-degree murder case when the medical examiner comes in and says, George Torres died from positional asphyxiation and the asphyxiation from being in a confined space. And eventually, after Lord knows how many breaths, he expired in that suitcase when she went upstairs and went to bed. But in addition to those statements, we now have her new statements, which are she intentionally violently shook the suitcase, threw it upside down, hit him with a bat, committed independent forcible felonies. And that's going to be corroborated by the medical examiner's testimony to all the blunt force trauma to both sides of his face and his mouth. That is a second-degree murder case. That is what we're going to be presenting. This is a portion of what I will be telling the jury this afternoon.
Any rebuttal?
I wanted that in writing weeks ago. She was a
Trying to pause. There we go. And so George was on the phone with his brother that night, and it's my understanding they had a good conversation. And towards the end of the call, Sarah starts yelling at George to get off because she wants to call her brother. Because it's my understanding that they shared a phone. So he used her phone to call his brother, and then she wanted to use the phone to call her brother. And that's the last time anyone in his family heard from him. That was the absolute last time. And so I just can't. I think that brother might be on the witness list because I'm not sure. I think that person might be on the state's witness list. He's the last person to talk to George. And it wasn't because Sarah was controlling him. And I think the state is going to present that George was the one that was the victim, that George was the one who was being emotionally, financially, physically harmed by her. And I think there's a strong case for that. I think there's a really, really strong case for that. So let's drink our water. Let's choose healthy coping skills. I'm joking. Because I know an uncivil law, I don't know if he's gonna do it. I know he created drinks for this case. So I created Boone Go cards. Ooh, I have them right here. Some people didn't think it was perfect. I'm not a therapist. I'm not your therapist. I'm not her therapist. So I have my cards ready to go for trial. And it starts with opening statements. Okay. So our Boone Go cards start for opening statements. It's on the community tab. If you have no clue what I'm talking about, go to my community tab, go to my page, click community, and then scroll down a little bit. And these cards are there. The PDF is available in my Facebook group. So there's a free Facebook group. You can just, I think you have to join, but you can leave it if you want. I barely do anything there. Honestly, I don't really do that much there. But I couldn't load the PDF here. So the PDF, I ran into issues. People figured it out, but the PDFs are available there. Yes. And so I love giving people credit. So when people come up with things, I love giving them credit. Legal E Blonde is the one that came up with Boone Go, because I was just going to do bingo cards. So normally with alcohol abuse, there's normally codependence. And I think because sometimes it can happen where one person says, hey, let's not drink, and the other person encourages someone to drink. It sounds like they both had an alcohol problem, and together that was a bad situation. So Sarah tries to say in her interrogation that she was the best thing that happened to him. The day after he's found dead, she has the nerve to say, I was the best thing for him. I helped him. I'm the reason why, whatever she said. His probation officer loved me. She had the nerve to try to be the reason he was so successful, when I personally think he would still be alive if he had never met her. If he had never ever met her, if he had stayed far, far away, he would probably still be alive. And those are just my personal thoughts, my personal things. But I think the term codependence came out of substance abuse, and it's normal to rely on each other. But what can be unhealthy is when I need you, when like I can't live without you. That's super like toxic. That's toxic AF. So I've mentioned it here before. My partner and I, we choose each other. I don't need him. He doesn't need me. I want to be with him. And he doesn't make me better. Like he isn't like it's not like him being in my life. It's not like my happiness goes from depressed to over the moon happy. No. Like him being in my life, like it's good, it's great, but like if for some reason he wanted to go, once again, I've said it here many times, alimony and child support. This is like he's not hostage. I'm not hostage, but we choose each other every day. And I think that's a healthy relationship. I think it's unhealthy to think that like I have to need you. Like you complete me. I think that's super. If any of my older people know what I'm talking about. Like I want to want you. I want to like so there can be trauma bonds when like we connect in our pain like that and we don't heal. And it's not my job to fix my husband. So if my husband is struggling with depression, I'm not his therapist. He has to get a therapist. He has to talk like I'm going to support him, I'm going to encourage him, I'm going to be there for him, but I'm not going to do therapy with him. Like that's dude, no. And it wouldn't work. So the thing that makes therapy work is working with a neutral person because it doesn't work when your friends tell you the thing. It just doesn't work. It's more helpful when it's a neutral person. I have like 10 more minutes. Oh, I'm sorry. I don't mean to call anyone out. I don't mean to call anyone out. And so it's normal to be sad. So if my husband left, I would be sad. Um and that's where the vengeful part of me would be like, you're about to pay. It was cheaper to keep me, dude. Like it was like I would that's the vengeful part of me. But I think it's toxic for people to feel they have to stay and there's no reason. But like so I believe that like because of the relationship I have with my partner, we choose to be together. And we also have a closed relationship. If I found out he was with another person, if I found out he was with other people, we talked about it. Our deal breaker was infidelity. That was a deal breaker for us. And so, hey, dude, if you want to go be with somebody else, and for, so you can just tell me and avoid, or like, but if I find out, like, uh, that's I will forgive you from like through our divorce and us now co-parenting. And he's aware, I'm aware, and it is what it is. But yeah. Don't date a therapist. They're not gonna like or they'll have bad boundaries because like if they try to fix you, that's like a therapist with like really bad boundaries. Marriage therapists sometimes have the worst marriages because you have to actually do the things. Like you can't just, like you can know the right thing and then like not do the things. So I do my own therapy. So I've mentioned here before, I manage anxiety. I've had panic attacks in the past. Um, at some point I might get assessed for ADHD. My regulars know, but and then my child is probably going to be he's probably going to have his first psychological by the time he's 8. He probably will. But yes. And it's okay for us to disagree. It's okay. We can disagree. You can give partner to ooh, okay. Well, so okay. But so in the United States, because I can't be having intimacy with a client. So that's where it couldn't be my partner. Those are just my thoughts. Let's keep it going.
Assessed, Sarah Boone, the defendant, was assessed at the Orange County Jail a couple of weeks ago by Dr. Warner. Their rebuttal, state's expert. The characterization that Mr. J just gave about her testimony, I do not agree with. There was 4 of us there. Dr. Werner, 5 of us there. Dr. Werner, Sarah Boone, myself, and the 2 prosecutors. The mistake we made was not recording that assessment. Because I can't testify to what she said. The 2 prosecutors can't testify to what she said. The only 2 people that can testify to what she said is Dr. Werner and Sarah Boone. We dispute their characterization of what she said. That's just going to have to be testified to by Sarah Boone and then Dr. Wood. And jury, while we're here, they are going to have to decide who to believe and what happened. But that is a jury question that we're all going to have to wait for. I appreciate the prosecutor giving me the evidence he intended to introduce to prove second-degree murder. It was something I was asking for a couple of weeks ago. Thank you.
For the same reasons that the court identified when we had the hearing on the original motion for particulars, the court relies on its same ruling in the case law identified at that time. The renewed or tennis motion for a statement of particulars is denied. The state's objections as to paragraph 59 and 60 are also overruled. The only other issue to address then is the Richardson violation. Court's going to take a short recess, and we'll address that as promptly as possible.
Let's zoom. Oh, wait a minute. Did they get to it immediately? Did they already cut it out?
It's 5 till 11. I still intend on moving forward with jury selection this morning. We will be moving to 23, correct?
Yes, sir. I'm just making sure I'm clear on 60. Our request was that prior to the testimony of any of the listed witnesses, which I listed only by initials, that we have the opportunity to depose them and we address the cost of expedited transcripts. I just want to make sure that's over.
So the judge is going to order that the defense has to pay for that deposition. We're going to go to the Richardson hearing. All right. Let's start here.
And have that hearing tomorrow morning at 9 a.m. Defense is to
tomorrow.
provide an edited version of only the records that pertain to anxiety or their lack of that thereof to the state before 9 a.m. tomorrow morning.
Judge, number 6 was cured by agreement.
All right. So I believe that was everything. So they are going to have that hearing tomorrow. So they are not going to finish the Richardson thing today. They're going to do that tomorrow. Y'all. This is I'm here for the ride. I am definitely here for the ride. And I so appreciate each and every one of you. And it's just, this case is tough. And it does look like I will be on Surviving the Survivor tomorrow at 5:45. So make sure to check that out. I think the stream might start at 5:30. I'm not sure. So I have to start at 5:45, but it does look like I'll be on Surviving the Survivor tomorrow. I'll make sure to share the link to that stream in my community tab. So that'll be, and talking about Sarah Boone. So I'm excited about that. We are going to talk about that. I'm not a lawyer, so hopefully a lawyer in the chat can answer this for you. When I Googled it, when I Googled Richardson hearing, it was a ruling about late evidence. So yes, because there were timelines in this case and things are being submitted later. And so, yes. All right. Samantha, I agree with you that, so in the United States, you cannot give therapy. So therapy is different to be like helpful, but I have really good boundaries. And because let's say I was doing therapy with my partner, with my husband, he could sue my license. Like he could come for my license, and that's just dumb. Like that's weird. And so it is true in the United States. It is true in the United States that you cannot give therapy to people that you are, because it's a dual relationship. So I cannot give therapy to my husband. That's how it is in the United States. I appreciate you all for being here, and I hope y'all enjoy the rest of your day. Bye.